President, please be seated. The court is back in session, and the chamber now is hearing oral responses and submission in relation to Nuon Chea and Khieu Samphan defense request to admit documents, 17 documents, and 6 others in relation under Rule 87.4 of the internal rule, so that those documents can be used in the examination of witness 2, expert witness 2CCE 88. This witness is scheduled to testify on 14 March 2016. Please refer to document E387 and E387/1. And the legal officer of the trial chamber sent an email to parties that the chamber is scheduled to hear the responses of the defense counsel's request after the conclusion of Mueang Chandi. And now the floor is given to the co-prosecutors to give responses to the defense request. So you may now proceed.
Good morning, Mr. President. Good morning, Your Honours. Good morning, Counsel. Your Honours, yes, we have received Rule 87.4 applications for documents to be used with Alex Hinton, TC 88. That's E387 and E387/1. In the main, in relation to Khieu Samphan's documents, we have no objections to them going in. They have asked for 5 documents to be admitted. One's his CV, his curriculum vitae. We think that's a good idea to have that in. The others relate to documents written by the expert witness and generally on the issues that he'll be testifying about. And the other relates to a critique on his book by Henry Lockhart. And that critique, albeit a letter to the Phnom Penh Post, like a few of the expert witnesses, they do contain some factual basis that they put forward for the discussion in relation to the critique of his book. In terms of the probative value of the documents, Your Honours, we submit documents that are used with witnesses take on a slightly different probative value than documents that are attended independently and not necessarily used for questioning. The reason for that is that ultimately the value of those documents will arise out of the conversations had or the questions in the courtroom. As far as the application for Nuon Chea is concerned, they've asked for 17 documents to be admitted, and apart from 2, which we would oppose, we would agree that 15 of those documents could be useful to Your Honours in ascertaining the truth, particularly in how they may be used with the witnesses, with the expert. The 2 documents, those 15 documents largely relate to documents written by the expert or documents about the expert, his biographical details, summaries of what he was doing or what he is doing in this area of work on the website, etc. We find that they will be useful. Where documents have been requested to go in, and perhaps this relates a little more to Khieu Samphan, in relation to arguments or debates about whether genocide occurred in Cambodia. As Your Honours have said in your decision, E388, designating this person as an expert, that issue of whether genocide occurred is an issue for the Chamber, and it's not an issue so much for the expert or a witness that comes before you. But what Your Honours have said is that the factual basis on which these conclusions are drawn can be helpful, of course, to assist you in arriving at whatever decisions you need to make on the issue. And so with that caveat, we accept those documents to go in. The two documents that Nguyen Chia's team would like to put in relation to this expert, and I refer to E387.1.14, and that's an article, The Problems of International Codification, Were the Atrocities in Cambodia and Kosovo Genocide. That's been written by a leading academic, William Shabas, and we oppose this one going in on the basis that, again, it's the issue of whether genocide occurred is a question for Your Honours. Unless the article or the document brings some significant or factual basis to support such assertions of which Your Honours may be assisted by, then a legal discussion on the issue we submit is not, it doesn't assist Your Honours in ascertaining the truth of the matters. And if Your Honours look at this article, you can see that it's an article arising out of a debate presentation where the significant facts are not really discussed. And even the first page of the article, you can see that there's no real discussion of the facts to support this opinion, where it says, indeed, the notorious emptying of Cambodian cities that characterised the beginning of the country's bizarre social revolution was accomplished peacefully. That's obviously not in accordance with the evidence. So we would ask that that one not be admitted because it's largely a legal opinion not based on facts. And the only other one we would oppose is E387.1.16. It's a opinion piece from the expert to the New York Times, and it includes a comment about his concerns in 2008 about the independence of the Cambodian judiciary that were appointed at the ECC. The first point we make is that that issue is not the issue in which this expert is testifying to. Secondly, the substance of that issue is so remote in time, it's vague in terms of its direct connection to this trial, and it certainly comes well before much litigation on these issues, of which these and other matters have been discussed about the impartiality of particularly this trial chamber. So we would submit that that is not of extremely negligible probative value, and we would oppose that that be admitted. So that's our submissions, Your Honours. Thank you.
President, and now the floor is given to legal lawyers for civil parties. You have the floor now.
Merci, Monsieur le Président.
Thank you, Mr. President. Good morning, everyone. We will rely on the discretion of the Chamber as regards all the documents presented by Kyo Sampan and the Nguyen Chia team.
President, now you have the floor, Judge Lavanya.
Oui, merci, Monsieur le Président.
Yes, thank you, Mr. President. This is rather a formal remark, but I noted that the documents in the annex of the application by Nonchia, it appears that some of the documents have not been presented in a very orderly manner. Document number 2 and document number 3, unless I am wrong, are wrongly numbered. That is document D. Document 2 has number 387.1.3 and the inverse for document number 3, and the same is true of documents 14 and 15. So may I request the Nunchia defense team to properly ascertain whether such numbering is correct, and if it's correct, or if it is not correct, the Nunchia team should file an application to have the numbers corrected.
President, the chamber gives the floor to the defense team for Mr. Nunchia. You may now proceed.
Thank you, Mr. President. To start with the last remark of Judge Lavenia, let me get back to that. If there is indeed a wrong use of numbers, we will file a new application as soon as possible, most likely today. Now, responding to the remarks of the prosecution, I think I can be brief in my reply. Indeed, 17 documents we're asking to admit into evidence. Maybe as a general remark, Mr. President, there are only 1 or 2 publications on the case file relating to Mr. Hinton. There's not much right now on the case file, only mainly his book, Why Did They Kill? Therefore, we felt it was necessary to broaden the extent of the evidence presented or given by Mr. Hinton, or the expert rather. So our documents fall into 3 categories. 3 documents are related to his background and methodology of research. 9 of our proposed documents are related to the expert's possible lack of neutrality and objectivity. And there are some general documents, 2 of them just now referred to by the prosecution. To finish my general remarks, half of the documents were not available prior to the start of the trial, and the other half could only be identified after the trial chamber rendered its decision on the scope of expertise of the expert, which, as you know, it did on 24th of February 2016. I think all parties agree that it is not up to the expert to make any statements as to whether or not genocide has taken place. Between 75 and 79, there is no doubt that that is only and exclusively within the realm of the trial chamber. However, the expert is not just anybody. Although not a lawyer, he has been involved extensively in all kinds of debates in relation to genocide. As a matter of fact, as the trial chamber itself has considered in decision 388, the expert was at one point in time president of the International Association of Genocide Scholars, and also held the UNESCO chair in genocide prevention. So although we certainly, and I presume all parties, will refrain from asking any questions to the expert as to the legal definition, I think the article of well-known expert Shabazz on the question whether cultural genocide falls within the scope of the Genocide Convention is something that should be admitted, because the expert challenges that very notion. But again, it's not meant to enter into a legal debate with the scholar, but it's just as background information as to his position that he has undertaken. I understand the objections from the prosecution in relation to the second document. Obviously, we will not question the expert at length as to matters of jurisdiction, be it personal or temporal jurisdiction, or matters of whether a fair trial at this institution is possible. Obviously, the trial chamber knows our position in this respect. It's merely meant as background to have a full and proper understanding of positions taken by the expert. So that's the background for those two documents that the prosecution objected to. That's all. Thank you, Mr. President.
បាទខ្ញុំក្រោយផ្ដល់ប្រកាសជូនទៅ
President. And lastly, the floor is now given to the defense team for Mr. Kyu Sampon. Kung Samon. Thank you, Mr. President. After hearing the responses from the co-prosecutors, and I know that they do not have any objection to the documents requested to be admitted, and in light of the submission by the defense counsel for Mr. Nguyen-Chi, I have no further observation. President, thank you. The hearing of submission and responses in relation to the defense counsel's request to admit documents has now come to an end. I am grateful, the Chamber is grateful to all parties for their submissions and responses in relation to above mentioned agenda, and it will be form as a basis for decisions of the trial chamber, and the chamber will issue the decision in due course. It is now time for the adjournment. The hearing will resume on Wednesday, March 2016, to hear 2 TCW 893 in relation to the treatment of targeted groups, namely JAM. And there will be, the chamber is still having 2 witnesses in relation to this fact, treatment of JAM. And it will hear the 2 witnesses in due course. And as far as you are concerned, the hearing is now come to an end, since 2 CCW 880 has a severe health issue and cannot be available for the testimony before the chamber. So the chamber has no reserve of witnesses to come in the replacement of 880. Security personnel are instructed to bring the 2 accused, Nguyen-Chi and Kyu Sampon, back to the ECCC's detention facility and have them returned into the courtroom on Wednesday, 9 March 2016 before 9 a.m. The court is now adjourned.